Good morning, good afternoon, good evening, everyone. On behalf of International Intellectual Property Law Association, I'm delighted to welcome you to today's webinar on trade secret versus patent strategic protection decision. Protecting innovation is a critical business decision. While they require public disclosure and have a limited duration. Trade secret, on the other hand, will be protected indefinitely, but only when the businesses take appropriate measure to present confidentiality. Today's session will explore how organization can evaluate these two protection mechanisms and determine the most suitable strategy based on their technology, commercial objectives, competitive environment, and enforcement consideration. It is now my pleasure to introduce our speaker, Mr. Aden Chen. Mr. Chen is a patent lawyer and managing partner of 𝐓𝐚 Partners Shanghai, a PRC law firm associated with Bird& Bird. He is licensed to practice in United States and California as well as in China. Before joining 𝐓𝐚 Partners, he led the China intellectual property practice as partner at Duane Morris Shanghai office. He has also served for several years of APAC Intellectual Property Director and Global Litigation Counsel at ExxonMobil. With more than 25 years of experience in intellectual property and commercial law, Mr. Chen provides strategic and business-oriented legal advice to clients operating multiple industries. As a patent lawyer, he assists companies in the life sciences, biotechnology, medical devices, pharmaceutical and chemical sector with patent prosecution, research and development, collaboration, technology transaction and patent dispute. He is one of the chief editor and key author of the book New Trends of Intellectual Property Right, Practice and Essential, published by Peking University Press. Throughout his career, Mr. Chen has spoken at numerous international legal forums, including IIPLA, sharing his insight into intellectual property law and commercial practices in China and United States. We are truly honored to have him with us today. So, Mr. Chen, thank you for joining us, and the virtual floor is all yours.
Thank you. Well, it's my honor to share with my experience and some of the practicing lessons, I believe, from my side, both as a practicing lawyer in the US and in China. And well, it is a new approach for patent plus trade secret protection. After certain changes of laws, especially after 2013's new AIA in the US, which is America Invents Act, which provide some opportunities which is not exist before for a due protection on certain technologies with both patent and trade secrets. So my topic is on, I should say, a better protection strategy for a due protection scheme of patent and trade secret. The agenda is similar as most of those presentations. We go through some summaries and the legal framework, some analysis, and all the way down to certain models, examples, and we will talk about the risk and the implementations and some enforcement strategy before our conclusion. Well, as everybody knows, patent and trade secret protection are different roads. Previously, it was divided into different legal system from two different approaches. But after AIA, some layered protection is available, and we can utilize it for better protection strategy for the technical solutions can be qualified as both patent and trade secret protections. Well, for most of the cases, as we know, there is framework on the patent disclosure, which for a patent to be patentable, your disclosure has to be enable the skilled in the art to practice your technology. This is a clear requirement which may be in conflict with the trade secret consideration, as we mentioned later. And for the disclosure, it has to be full, clear, concise, and exact, so as the person skilled in the art can make and use the invention. Well, it is understandable for the whole rationale under this policy, because it was a bargain in the beginning for invention to be given a monopoly in exchange for the public disclosure, which will enable people to further research based on the technology and utilize it upon the patent expiration. Well, the disclosure has to be at a level of a full disclosure without undue experimentation, which means you have to disclose the technology with certain details to help any person want to utilize the technical solution to achieve the result as you claimed. That's a requirement for the patent framework. For the trade secret, there are multiple layers of the requirements or regulations. In most of the industrialized countries, who is a party of the TRIPS, there will be a conventional, a convention obligation for protecting trade secret. And for US at the federal level, the Defend Trade Secret Act, a new one, is at the first time to put the trade secret protection at the federal law, which comes to third typical IP for protecting not only technology, but also the trade confidential informations. And there are also state laws and certain uniformed trade secret acts exist in the US. The basic requirements for trade secrets is from three, criteria. The first one is it has to have economic value, which should be a giver for most of the protectable trade secrets. The economic value has been assumed. The second one is reasonable secrecy measures, which might be a trouble for certain companies if they don't take care of those documentations from the beginning, which we'll mention later. And the third one is the one conflicting with the patent mechanism, which is the technology has to be not known to the public from the TRIPS requirements. The information has to be secret as a body or in the precise configuration and assembly of its components, which has some meaning, I think, invite some kind of different interpretation. Is it mostly on the details of the components or on the overall configuration, which we'll touch with more discussion later? The two legal framework obviously has a conflict. In the patent side, the inventors have a duty to disclose to the public through the office all the information material to the patentability, which means it is necessary to disclose all those features to enable the patent to be practiced in reality, which we mentioned the enablement requirements. However, the information disclosed cannot be a trade secret anymore. Those are the issues and the key focus in the case laws most prominent in this area, Goodyear and Troy. IIPLA has some discussion on the disclosure to be protected under confidential obligation in the meantime to meet the requirement for the patent disclosure, which is a 724 section in IIPLA. And we will touch it with more discussion later. Well, in facing of those conflicts, there's a pathway available, well, I should say, already more than 10 years ago, but it hasn't been popular until recent years. The written description requirements for a patent, not only in the specification, but also in the claims, has to be specific, has to be complete. And in the years before 2013, which is AIA effective year, it has best mode requirements, which requires every applicant to disclose the best practice in their enablement in the specification for the best practice they know before the filing of the patent. And those requirements can be a vulnerable part for the patent invalidation. However, AIA changed the rules, which is a subtle difference. It still kept the requirements for the disclosure, but it removed the invalidity ground based on the best mode. That means best mode cannot be used for invalidating a patent or against the enforcement of patent anymore. Thus, it leaves an opening and a pathway for protecting the patent-related know-hows parallel with the patent rights. That's something we will discuss in details in this seminar. In the previous protection models, we may see those are mostly separated because of the different framework of the legal requirements and also the court practice based on different mechanism of the trade secret versus patents. That's why for most of the cases, the protections are separated. For certain technologies, something like we all know, the beverage formulation or some secret formulas, it has been protected purely by trade secret. That means no patent is filed. The entire technology is maintained as a trade secret. Well, this kind of protection will be suitable, and still it is some major practice for certain sectors of the industries if the technology is entirely internal to the company's operation, or it is very difficult to reverse engineer from the final products. A pure trade secret protection has the benefit of unlimited terms, but it cannot prevent independent research and development or a reverse engineering attack. The second model is the pure patent protection. Well, for most of those commercialized products, like consumer electronics, general purpose circuits, or simple mechanical devices, patent protection is paramount. And you may see for most of those technology, the technical features are disclosed in patent, no trade secret are retained because it has to be laid open to get the patent granted. Well, the patent can only be valid for protection for 20 years from the filing date. That's the drawback. But the patent protection can be more, I should say, streamlined in the legal practice. and those injunctive reliefs are more readily available for patent litigations. Now we know there are third protection model, which is a layered dual protection to use both patent and trade secrets. And for the patent layer, it locks down the rights on the basic mechanism, framework, and the functionality of the technical solutions. And at the trade secret layer, the protection will be on the optimization details that will create competitive advantage. And for this protection model, it will be more appropriate for the technologies with some aspects as reverse engineerable, but the other aspects are not. So that you can protect with certain secrecy, and with those has to be laid open in your products, protected by a patent. And that's why it is getting more and more popular. And let's see how this dual protection works. And the key is dividing the technical solution into layers. The legal principle or legal rationale behind this approach is patent covers the essential and trade secret covers the optimization. And in the patent, you have to disclose all the necessary technical features to have those enablement requirements to be met. And those features not required for the option and for the practice with the basic functionality can be withheld as trade secrets. And the layers of the technical solutions, as a summary, will be patent for the essential features and the trade secret for those details, something like the efficiency, the precision, or the cost effectiveness. And here's a table summarize those considerations. And for those layered technical solutions, it has certain requirements you have to take care of, and a certain advantage and disadvantage you have to consider if you have to decide in a separate pathway. But for a dual protection, if you divide those technical solutions into the patent disclosure and the confidential information, which can be protected as those optimized solutions, you can have both. Well, let's see for some industry examples. For the mechanical or equipment technologies, in order to get the patent protection, you have to disclose the overall machine structure, connection relationships, necessary transmission, operation, that kind of mechanism, and the basic assembly steps. at the trade secret level, in parallel with the patent protection, you can still protect your precision tolerance, some calibration parameters, those details in making your product better than others. And you may put your certain parameters and conditions under the trade secret protection as well. And let's see for another industry, which might be different in their division of those two layers. For pharmaceutical, chemical, and some related industry, for a patent, you have to disclose the core compound structure, that's for sure. And you have to disclose the basic synthetic routes and the general compositions. However, in the same time, you may want to withhold those information on the exact weight percentages for the compositions, the optimal temperature, and other parameters, and even the catalyst amounts in the reaction. And you can also withholding the information on crystallization, the cooling curves control, the drying vacuum levels, and the purification process. So those part, and you can keep it as secret in your practice to keep the competitive edge against the competitors. For another industry, software, algorithms, and even related electronic devices, to get a patent, you have to disclose the overall process flow, input, output logics, and you have to make it clear the functional module architecture is disclosed, and you have to describe the basic data process framework to enable the whole program to work. However, at the secret level, you can still maintain those information on the model training weights, especially for the AI models, the loss function tuning parameters, which is also important for adjust your model. And you can withhold those features, selection thresholds, optimization operators, as well as the server's parameters. Obviously, those confidential information can give you certain advantage in the computation. However, those information, if it is in danger, or I should say, make the disclosure not enough for enabling the whole patent, it will be a risk. For the due protection strategy, the distinction can be summarized with the information relates to what can be made has to be disclosed. The information related to what can be made well or better can be withheld as a trade secret. Since AIA eliminates the risk of invalidation or the unenforceability of the patents, it gives the room for protection of those information previously has to be disclosed by the best mode. Now we can hold it as a trade secret, still without endanger the patents. Well, there are certain risks for the layered dual protections. The problem, I should say, the core problem is still the intervened disclosure. This is also something the USPTO has to be dealt with. The core issues is whether or not you claim to be the optimization details are essential with the basic invention. If it is some kind of essential information or critical to the patentability, which is the novelty or the inventive steps, you may risk of a finding of lack of enablement, which will in turn to be a ground for invalidation and enforceability. So that's the legal consequence. You have to take it seriously. Otherwise, the patent won't be protectable. The withheld information, if you think it can be something only optional or non-essential to the basic technical solution, you can still argue, but the judiciary system will be the final say to determine whether or not the enablement requirements has been met in your disclosure. So there is always a risk. And that's the trap for the patent protection. Obviously, for the exchange of the monopoly, you have to make a public disclosure on those information. However, those technical information will be permanently loses the status of trade secret. Those disclosures are not only in the claims and the specification, it can be in your information disclosure statements and your later arguments and amendments submitted to the USPTO. Well, for the trade secret part, if you are claiming trade secret protection, you have to identify with a reasonable particularity. That means a vague description of broad categories of features or components are not enough. However, to articulate the technical know-how, you have to think about certain level of the abstraction to cover some kind of modified technical solutions. That means if you claim your trade secret too specific, which will be only on those details of its components instead of the overall configuration, which can also be protected at a level of the abstract if it is capable of being protected by trade secret. That's the dilemma for certain practical issues in the patent versus trade secret due protection mechanism. And how can we do that? I have some practical suggestions which can serve the implementation guidelines. First of all, the pre-filing technical review has to be done. So do your technical inventory check systematically to separate those essential technical features from those optimization features. Step 2, create a cross-reference table. That will help you to document the classification of each features and the rationale for each decision, which will in turn help you in the patent drafting and later on the trade secret characterization and documentation. And step 3, that will be the separate storage for the files, for the patent filing, which will be disclosed, and for the trade secret storage, which will be kept with certain measures. You have to store the trade secret documentation separately from the patent files. Otherwise, it may be disclosed or involuntarily, which will be pretty bad. And you have to label all those trade secret documents with appropriate confidentiality markings. And you have to also document the measures you take for keep them confidential, such as the access control and the trackings of the access. And the above steps is built on some kind of operational principle based on the low bound disclosure strategy. That is drafting the patent application to disclose only general range of the technology rather than the optimal values, so as to satisfy the enablement requirements while preserving certain technical details as trade secret. Some practical examples we may think about is to separate the functional parts versus the specific devices, which in your best mode, to separate the disclosure temperature in a range versus optimal temperature at the process level, and to separate some general component classes versus certain exact measurements or some kind of specifications. And you can also separate the basic processing steps versus the process control parameters with certain optimization. So that's the guidelines for the basic practice before the filing. And with the US PTO prosecution stage, obviously you have to meet your duty of disclosure. And in the meantime, you can claim the trade secret protection as well as the new rules in MPEP. The required procedure for submitting trade secret information in the patent prosecution is to clearly label documents as trade secret material, identify those information by page, lines, and even words, and submit it in accordance with the requirements procedure. The issue to be noted is USPTO will not determine what is proprietary, which means whether or not it is confidential, it is in your trade secret. That's not their concern. Their concern is if you don't properly designate it as trade secret materials, and if you don't file a petition for expungement, it will be made public. So you have to follow those procedures to keep those trade secret information confidential. Well, in the prosecution open to the public. For the document or the information and certain technical features to be protected as trade secret, you have to meet certain requirements, which is specified under the Trade Secret Acts. You have to have those confidential agreements with employees and contractors. You have to have those control on the access and the logging into the information. You have to take the physical security measures as well as the electronic security measures. You have to have your training program in place for trade secret protection, certain education and trainings, and you have to implement certain exit protocols for departing employees. Those measures can make those information covered by those measures protectable, in addition to the specification on the trade secret disclosure and description, as we discussed before. How to enforce this dual protected technology? Obviously, if you want to utilize the double protection, you have to meet the requirements and you have to take actions to protect both rights in patent and in trade secret. For those infringement by the competitor copying your patent technology, obviously that will be the patent infringement litigation. The available remedy will be injunctions, damage, triple damage, something available in the patent system. And for those trade secrets, in addition to the protected framework of the patent, if they also used those detailed parameters and detailed know-how, you can protect those by trade secret misappropriation litigation as well. And the available remedy will include injunction, damage, and sometimes attorney fees. All those remedies can be available, simultaneously or both for a patent holder with trade secret protection if they do the legal actions right. And in certain situation, there will be a stolen patent, which associated with your trade secret, filed by a third party as their patent. In this particular situation, obviously you want to get the patent back by claiming the proper inventorship and the ownership of the patents. And you can also claim the trade secret protection for the destruction of the secrecy value. Obviously, the third party's patent disclosure destroyed the status of trade secret, and the return of the patent probably won't be enough to address your loss. Something like it's a reason for choose trade secret protection because it can be longer, can be more complete, which can also be more exclusive. Those values can be hard to be supported, but it's something worth to pursue. The above discussion is pretty much what I have. In conclusions, it is available protection strategy to have a layered dual IP protection utilize both patent and trade secret. The core principle we have to observe is the patent disclosure has to enable the invention, and the optimized practice can be protected by trade secret. And in doing that, you have to classify your technical features into two layers of the categories. The essential part has to be disclosed. Those details for optimization can be retained. Well, by this dual protection strategy, you can get the benefit of 20 years of the exclusive rights for the invention, which is on the basic technology, and the perpetual protection for the optimized know-how. And the risk and the measures you have to take is to take care of the public disclosure versus the details you can withhold. But you have to be mindful in those reverse engineering attack. Those part probably is not suitable to be protected by the trade secret. You have to be mindful. The inadequate disclosure may invalidate the patent. And you have to make the planning and the documentation required by the law all the way from the beginning of the R&D stage to protect those trade secrets. For the measures or the strategy to be implemented, it has been suggested to conduct a technical feature inventory track for each technology assets, classify features into patentable patent filing information versus detailed optimization confidential information. And in the drafting of your patent, utilize the low bound disclosure strategy. And you have to implement those protection measures as required by law for your trade secret status to be recognized in the court. Well, for all those measures, you have to maintain clear documentation and the secrecy record to enable your protection later if you have a dispute. Well, that's pretty much all. If you have any question, you are more than welcome to ask. Thank you.
Aden. Thank you so much for insightful and the practical presentation. So, believe the discussion has provided valuable guidance on how businesses can access whether an innovation should be protected through patent, maintained as a trade secret, or managed using a combined intellectual property strategy. We'll now begin the question and answer session, and I invite and encourage all our participants to submit their question through question and section or chat box. We'll try to address as many as question within the available time. So Chen, if you can open the chat, you can see the three questions. One from Nicholas in the Paul and the Ruby. The first question is by Nicholas, which is, what are the most common mistakes companies make when managing confidential, technical, or commercial information? That's the first question by Nicholas.
Well, thank you, Nicholas. Let me get to the question.
You can close your presentation and click on the chat box and see the three questions listed over there.
Okay, let me get there. Let me stop sharing.
Yes.
Okay.
Now you can open the chat box.
Yes.
Right beside the participant, and you have a three question, one by Nicholas, the second by Paul, and the third by Ruby.
Nice. Well, now you can see.
Okay.
Well, the common loopholes or some kind of mistake for protecting the confidential information is to lose those record on the protection measures to make those confidential information unqualified for trade secret protection. As we may know that there are three requirements for trade secret to be protected by law. Those are the TRIPS standards implemented into the national law in most of those industrialized countries. The critical one is the secrecy requirements, not known to the public. For that part, it has to be in certain level of the information hasn't been disclosed by the public. That's the requirements on the information itself. But the protection measures is more on the holders or the company and the technology owner. That's their required steps to take. That's sometimes tricky. And if we think about how watertight it should be for the protection measures, it's not as airtight as like a safe box. Nobody can break it, so long as it is reasonable, which is the standard. It's reasonable in the industry practice, it will be recognized. You don't have to be in some stringent measures preventing any exchange of the information inside the company, or you don't have to put everybody under a written notice or contract when it is allowable to access those information. Certain measures has been recognized, something as we all know in our email disclaimer. It may say, well, this is confidential information intended only to the senders. If it is mistakenly sent to the wrong receiver, please destroy it and notify the sender. That in most of those disputes has been recognized as an adequate measure to put certain information under the confidential status. However, there are certain disclosures. If it was made by your employee or the company's action, even not voluntarily disclosed to the public, something like the online video showing the process of the manufacturing, using as an advertisement for the company's capacity to make good products put on the internet, that may make certain information losing the confidential status. Sometimes the employees has to be taken care of with certain precaution. Majority trade secret cases are between the employer and the employees. The employees certainly has some legitimate rights to carry on with their career with those skills and experience they acquired in their working experience. However, they cannot take those proprietary information with them. That means to separate those skills, visions from those operational information as something you have to take care in the employment contracts and also in the exit protocol for the dismissed or discharging employees. Those are some considerations I can think about for that question. Let me think. Let me see if where's the second question. How does the risk of reverse engineering influence the decision between patent and trade secrets? Well, this is a good question. Sometimes it's very difficult to decide which technology should be protected by patent versus trade secret protection. Reverse engineering is a critical consideration to think about it. Once your product or even services to be put on the market, certain information will be laid open to the public. The reverse engineering is somewhat encouraged by different principles of the consideration. Something is the purchaser or the legitimate owner of the final products. They can do whatever as a property owner to the products. That's the public interest to be protected. And that's why if the patent, if the information can be discovered or obtained from the patent, not only on the surface, but also on the dismantle of those parts, or even something like the chips, they may use a layered investigation to figure out the chip design. So those parts will be vulnerable. I mean, that kind of technology will be vulnerable for the reverse engineering attack. There is some legal considerations or restrictions on the reverse engineering. First of all, you have to be a rightful owner of the products. If you are an infringer, if you obtain the information or the products illegally, reverse engineering won't be a defense for the information you obtained. Does this answer addressed your question, Paul?
Yes, I believe it is very well addressed. We can move ahead to the next question now, because we are running short of the time.
Okay. Well, another question is, what type of the technology or invention generally better suited for trade secret protection than patent protection? We have discussed a little bit during the presentation. Trade secret protection is more suitable for those technology, like typically on the internal process, which is not readily accessible from the outsiders, and also applicable to certain technology, which is not readily reversed engineerable. Trade secret protection is not absolute. It's more like status you can keep as long as you maintain the secrecy legally. Otherwise, it may lose that kind of protection even quickly than a patent. So for the trade secret protection, you have to think about how much effort you can put in for the protection measures, and how detailed or the difficulties of outsider access to the information itself. And typically for certain method technology or process technology, it is more suitable for trade secret protection, especially in the chemical and pharmaceutical industry. In the process, pharmaceutical industry is more unique because of the regulatory requirements and need some mandate disclosure. So our pharmaceutical industry will typically use patent to protect their key technologies, but they can protect those confidential technical know-how with trade secret on those fine details on optimize their products. So that's pretty much the consideration for the trade secret protection. As we may see, even for a patent protected technology, you can still utilize the dual protection strategy to protect those details for optimization. Certain parameters you don't have to disclose, and those can be the competitive edge, make your position stronger in the market than your competitor. That's my answer. Thank you, Ruby.
Okay, now let's move to the next question. It's by William Carter.
I don't see any more questions. Let me check.
So it's William Carter. With the growing use of artificial intelligence and collaborative digital platform, what new risks are emerging for patentable invention and trade secret?
Let me get to the. Can you repeat the question? Sorry, I'm
okay.
I have difficulties to access those.
Okay, let me again. Wait a moment. Yes. With the growing use of artificial intelligence and collaborative digital platforms, what new risks are emerging for patentable invention and trade secret?
Well, that's a good question for, I should say, this new era of the collaborating economy. Nobody can invent without build up those technology based on the previous technical achievements and certain information available already to you. And nobody can make great invention by itself, by himself, or by the company itself. So a certain collaboration is necessary. And that's why there are a bunch of legal devices you have to utilize to protect that kind of collaboration or the collective efforts on certain technical achievements. That includes those non-disclosure agreements, some non-compete provisions in the contracts, and certain we may see like the control of the information access with the electronic mirrors. However, the AI can make it more and more vulnerable on certain encryptions or even the access can be covered as a legitimate access to destroy those firewalls and the protection layers. And that kind of access, if it can be proved, that's also illegal access. Those action can be I should say, attacked by legal actions against the wrongdoers. I think most of the cases I have been dealing with in the US and in China are still utilize the reasonable standard for the protection measures. That means you don't have to be like at the highest level of the protection to make your trade secret protectable. So long as it is an industrial practice, it will be recognized. For certain industry, the exchange of technology is more often or more, I should say, available than others. So the protection level is different. But so long as you put those third parties or the accessors to the information under notice of the obligation of the confidentiality, you should have those legal position to claim. That's my answer.
Okay, so now we can take the last question. It's by Ben. What are the most important factors a company should consider when deciding between patent protection and trade secret protection?
Well, that's still comes back to the general principle as we discussed with more focus in the presentation. The decision on patent versus trade secret protection is more a business decision. In most of the parts, the patent protection, although with a shorter period of time, I shouldn't say short, 20 years from the filing date, is pretty long. But is still considerably shorter comparing with certain technology you can keep confidential as long as it is in your hand. Obviously, the protection term will be a consideration. But the protection strength is also a consideration in favor of the patent. Patent protection is more, I should say, straightforward because of patent to be protected as a technical solution has been endorsed by the patent office. You don't have to go through the judiciary entitlement process as the trade secret litigation, which is during that process, you have to go through those steps to prove that your trade secret and your technical know-how is qualified to be protected by the trade secret protections. That might be some consideration you have to think seriously, which includes the danger or the risk of those information can be independently developed by a third party. And it also includes a consideration on the cost and those efforts you have to put to protect those information. Sometimes it's not easy because it has to be a systematic approach. And sometimes those documented steps may not be recognized by a certain jurisdiction. And the patent protection sometimes has disadvantage of the jurisdiction separation. If you don't seek the patent or if you haven't obtained a patent in a certain country, you cannot protect your technology over there. But trade secret miraculously has certain long arm power. it has been recognized in the US case law, even if the trade secret holders in the US, it was misappropriated in other countries, it can still be actionable. That means trade secret protection can be powerful as one of the top consideration for IP protection. I should say, as a business decision, for most of those technologies, once you lay it open as a product, it may risk some follow-up copycats. You'd better to protect it as a patent. But for certain information, which is more operational in your not only business operation, but also the manufacturing process, probably you can protect it with the trade secret, which will give you better edge in computation. That's all.
All right, that's, I believe, the end of the session. Really very wonderful. So, which you have highlighted the decision between the patent and the trade secret. That's not a simply legal choice, but yes, on behalf of IIPLA, I would like to thanks to our participants for joining us and contributing their question. And I hope you find this session very informative and useful. So stay connected with the IIPLA for the information about the upcoming webinar, conferences, and IP initiative. Thank you once again, Mr. Chan, for this wonderful session, and to everyone who have joined us today. Thank you. Have a wonderful evening or a day.
Thank you. Thank you. Bye-bye.